Okay.
Okay, sedia. Assalamualaikum and good evening. So we are from Group 4 and today we will present about our topic, which is objects are specially protected under international humanitarian law. So for the introduction, basically international humanitarian law establish provision for the general protection of civilian objects and property, which this kind of law and regulation is forbids attacks, reprisal or other acts of violence against such objects in both whether internal and also international conflict. So basically, international humanitarian law also sets forth certain more specific rules to reinforce the protection of some of these objects, which this specific protection is sometimes linked to the fact that the objects in question carry a distinctive emblem that is protected under humanitarian law. So, what I can say that this protection is covered by the provision of humanitarian law conventions, which it's applicable to international and also non-international armed conflicts. So the study on the rules of customary international humanitarian law, which is published by the ICRC in 2005, customary IHL study, which this study have recognized that these rules are equally binding in international and also non-international conflict, except in rare exception. So these rules are binding on all parties to the conflict, and even those who have not or cannot sign the convention, such as non-state armed groups and so on. So that's for the introduction, and we will move to point number 1.
All right, for the point number 1, we have civilian objects. Civilian objects are defined as all objects that are not military objective. Military objectives are limited to objects that, by their nature, location, purpose, or use, make an effective contribution to military action, and whose total or partial destruction, capture, or neutralization offers a definite military advantage. In case of doubt concerning an objective or an object normally used for civilian purposes, such as place of worship, a house, or a school, the parties to a conflict must presume that such an object is not being used for military purposes. According to study records that civilian objects are all objects that are not military objective, while rule because that civilian objects are protected against attack unless for such time as they are military objective. Those rules are applicable in international and non-international armed conflict. And then humanitarian law prohibits acts of violence, attacks, and reprisals against civilian objects. Attacks that strike both military objective and civilian object indiscriminately are forbidden, as are those whose primary purpose is to spread terror among the civilian population. Then humanitarian law establishes specific precaution that must be taken to limit the effects of attacks on civilian objects and population. And then whereas requisition is allowed under certain conditions, pillage is strictly prohibited. Furthermore, extensive destruction and appropriation of property that is not justified by military necessity is considered a grave breach of the Geneva Convention. And then this protection is complemented by a corollary obligation that armed forces shall not use goods or persons in order to render certain points or areas immune from military operation. In particular, in attempts to shield military objective from attacks or to shield favor of impede military operation. And then the convention further specify that medical units must under no circumstances to be used to shield military objective from attacks. This specific protection granted to medical units is further developed in the entry on medical services. And then for the last one is humanitarian and relief organization have the duty to ensure that relief supplies are not diverted and used for military purposes. Otherwise, such organization risk losing the protection to which they are entitled under the status of civilians and will be exposed to attacks. Thank you.
Dengar tak? For the second object that are specially protected under the international humanitarian law is medical unit and transport. So, first of all, I would like to share the meaning of the medical unit and transport with you guys. So, the term medical units refer to establishment and other units include military or civilian, fixed or mobile, permanent or temporary, organized for medical purpose. The term includes, for example, hospital and other similar units, blood transfusion centers, preventive medicine centers and institutes, medical depots and the medical and pharmaceutical stores of such units. So the term for medical transport refer to any means of transportation, include military or civilian, permanent or temporary, assigned exclusively to medical transportation under the control of a competent authority of a party to the conflict. This includes means of transportation by land, water or air, such as civilians, hospital ships and medical aircraft. So the specific protection for medical units and transport under IHL is a subsidiary form of protection afforded to ensure that the wounded and the sick receive medical care. The IHL protection for medical units and transport is an old one. It can be found in the 1894 Geneva Convention or the 1899 and 1907 Heart Regulation. It was further elaborated in the first and fourth Geneva Convention for military medical units and transport, civilian hospital and certain means of medical transport. In 1977, this protection was extended to cover, in particular, civilian medical units and transport in all circumstances. Protection for medical units and transports in non-international armed conflict is derived implicitly from Common Article 3, which requires that the wounded and the sick be collected and cared for. This protection is also explicitly set forth in Additional Protocol 2. State practice has now established the obligation to respect and protect all medical units and transport, whether civilian or military, as a norm of customary international law applicable in both international and non-international armed conflict. So in the obligation to respect and protect medical units and transport exclusively assigned to medical purpose in all circumstances. So by the means of respect, it means that in particular that medical unit and transport may not be attacked and that their functioning may not be unduly impeded. By the means of protect, it means that medical unit and transport must be actively assisted in their functioning as well as protected from attacks or undue interference by third parties. In particular, medical units must, as far as possible, not be situated in the vicinity of military objectives. Moreover, medical units and transport may, under no circumstances, be used to shield military objectives from attack. So that's all from me.
Okay, so for the point 3, which is cultural property. So cultural property is also regarded as the object that's specially protected under international humanitarian law. So the special care must be taken to avoid any damages to the cultural property. So basically, cultural property means any movable or immovable property dedicated to dedicated to religion, art, science, education, or charitable purposes or historic monuments. And the legal basis for providing special protection for cultural property is found in the 1907 Hague Convention, 1954 Hague Convention on the Protection of Cultural Property in the event of armed conflict and its protocols, and in the additional protocols of 1977. The obligation to respect and protect cultural property also exists in customary law, governing both international and non-international armed conflicts. So, in the obligation to the respect and protect cultural property, respect means that the special property must be taken in a good care in order to avoid any damages, unless they are turned into military objectives. And to and protect means that all seizure or destruction or damage done to the cultural property is prohibited. So the aspiring power must also prevent illicit export of cultural property from occupied territory and must return illicitly exported to the competent authorities of the occupied territory. So that's all for point 3.
Okay, so for the next one is the natural environment. So humanitarian law also established specific provisions for the protection of the natural environment. So basically, armed conflict can cause long-lasting damage to the natural environment. For example, the use of certain weapons, in particular chemical or nuclear weapons, may have a long-lasting adverse impact on the environment, and such impact can be either an aspect of military strategy, and also parties to the conflict targeting parts of the environment in order to weaken their enemies' capacities. But in this situation, it may also occur as an unintended consequence of conflict. So, for example, such as destruction of drains, power station, and chemical plants and other industries, and also the mere creation of rubble may also result in the contamination of water sources, and also affecting the health of entire population. So, due to this situation, therefore IHL recognize a limit to environmental damage. Okay, so the environment is generally protected as a civilian object, and therefore also protected against direct attacks as well as against excessive incidental damage. And besides that, IHL also requires that all feasible precautions be taken to avoid and in any event to minimize the incidental damage to the environment. And the natural environment is accorded special protection under IHL. And based on the Article 33, subsection 5, and Article 55 of 1977 Additional Protocol 1 provides that IHL protects the natural environment against the widespread, long-term, and severe damage. So it means that it is prohibited to employ methods or means of warfare that are intended or may be expected to cause widespread, long-term, and severe damage to the natural environment, and which may threaten the health or survival of the population. And this also comes from Article 14 of 1977, Additional Protocol 2, which the principle that established that hostilities must not destroy objects that are indispensable to the survival of the civilian population. That's all from me.
but not least, last point for specially protected under IHL is works and installation containing dangerous forces, namely dams, dikes, and nuclear electricity generating stations, as well as other military objectives located at or in the vicinity of this work must not be target of attack. This applies even when these objects are military objectives. If such attack may cause the release of dangerous forces and consequences severe losses among the civilian population. The few derogations that allow are strictly regulated. First, attack shall cease for a dam or dike only if it used for other than its normal functions and in regular, significant and direct support of military operation. Second one is the protection of against attack shall for a nuclear electrical generating station only if it provides electric power in regular, significant and direct support of military operation, and if such attack is the only feasible way to terminate such support. And the last one, the special protection also shall cease for other military objective located at or in the vicinity of these works or installation only if they are used in regular, significant, and direct support of military operations. Furthermore, these works or installations should be marked with a distinctive emblem consisting of a group of three bright orange circles placed on the same axis. Next one in Article 16 of International Humanitarian Law and Rule 42 of the customary IHL prescribe that particular care must be taken if works Rule 42 of the customary IHL study prescribe that particular care must be taken if works and installations containing dangerous forces, namely dams, dikes, and nuclear electrical generating stations, and other installations located at or in their vicinity are attacked. Which means that especially protection against uh, this type of installations must be protected under the IHL. And this rule is applicable in international and non-international armed conflict too, based on the Statute of International Criminal Court that adopted this rule. And war crime include uh, international armed conflict and deliberate launching attack against civilian objects are specially protected under IHL and cannot be attacked. Okay, that's all for me.
So, hi, my name is Syuhada. So, to conclude about our discussion today relating to the our topic, which is object are specifically protected under the international humanitarian law. I've read about the report made by the Office of the United Nations of the High Commissioner for Human Rights relating to the attacks against a protected object in Central African Republic, where they stated that a core rule for international humanitarian law is that parties to the conflict must at all times distinguish between civilian objects and military objectives. So attack may only be directed against military objectives. So civilian objects are protected against attack unless and for such time as they are military objectives. For example, schools, hospitals, and religious buildings are in principle regarded as the civilian objects, and it is protected against whatsoever action by the military. So special care must be taken in military operation to avoid damage to buildings dedicated to religion or education unless there are military objectives. So international humanitarian law also specifically protects hospitals and medical units. In addition, under the International Criminal Court Rome Statute, in non-international armed conflict, it is war crime to intentionally direct attacks against protected objects, namely buildings dedicated to religion, education, art, science, or charitable purposes, historic monuments, hospitals, and places where the sick and wounded are collected. So, um, in this report also, I've read about many problems or war crimes that had been done by the Central African Republic countries where they have attacked the religious places such as church, mosque, and wounded the innocent people. So this kind of acts will lead to the war crimes. So under the international humanitarian law, they will be subjected to the punishment provided by the international humanitarian law. So the topics that we are discussing about uh, uh, regarding the civilian objects, medical units and transport, cultural property, natural environment, works and installation containing dangerous forces, they need to be protected. No, they cannot do an act which amounting to the war crimes to this specifically object, so that they will not be subjected to the any international court. So that's all from us. Thank you.